Hello, hello. Welcome to the first community table of 2026. Can everybody hear me okay? Hi, Naz, Abby, Megan, Monique, Roshni, Sam, all these people I know. Okay. I'm waiting on Rebekah, our speaker. Yeah, Sam says, hope all is good. I hope everybody has weathered this storm okay. I'm recovering from knee surgery and stuck at home. So, um, all right, Michael Trent from St. Vincent de Paul, good to see you. Um, so the storm, even if I had wanted to get out and felt like it much with my knee, the storm has kept me from doing that. Um, some of you all sent questions ahead of time, and I appreciate that. So I'm a little worried about Rebekah here. Okay, she just emailed me asking me for the link. Hold on just a second. I appreciate everybody's patience. Technology is wonderful until it's not. Let's see. Panelists. Okay, she's still trying to get logged in. Okay. All right. Thank you, Abby. I do feel great. Abby says you look and sound great. I appreciate that. Okay, so we got Melina, we got several of our shelters represented. Sam, how is the new job going? Are you feel like you're getting grounded? All right, Family Scholar House is here. Two, okay. Safe places here. Okay. And I know I got applications from a good many of you for the 2026 Case Management Institute, and I hope to have made those decisions by Friday. and notify everybody of who gets a slot. We had way more applications than slots this year, which means that some people won't be able to get in, but it does mean that there's a lot of interest. So that makes me feel good. Hey, Nick from Wellspring and Gary from VOA, Tina from Seven Counties. Okay, looks like we've got a good cross section of friends here today, friends and colleagues, Center for Women and Families. Okay. Kendra from St. Vincent de Paul. Zero V. Okay. New Life Directions Ministries. Welcome. All right. Rebekah says she has the link. I don't know. I feel like maybe I need to burst into song or something to keep everybody occupied. Amber from Up. Welcome, Amber. Catholic Charities. Good. Another Zero V. Okay. VOA. Up. Another from Center for Women and Families. We had about 50 people sign up. Usually we have about 2/3 of whatever signs up. House of Ruth, St. Vincent de Paul, Zero V. Zero V's got a good showing today. Thank you all for coming to this. This is a very important topic. House of Ruth. Monique's got her hand raised. Monique, can you put it in the chat? I'm getting a little concerned. She said she got the link. Timbury to everyone would love to network with all who are willing. Is there an efficient way? Well, Tim, I think Bagels in the Basement is going to be your best bet. And those invites will probably go out later today or tomorrow for the first Friday in February. So it'll have all the information. That is our big networking event with all the different agencies. That's the first Friday of every other month, even numbered months. So we get together, we have bagels and coffee down in the basement, and it's a good opportunity to meet people from other agencies and see who does what and how they do it and what's new, and um, ask questions. And if you have cases you want to talk about or share resources or get resources, um, that is the opportunity to do that. And a lot of the people that are on this training today come to those, or their agencies do. So I'll make sure, Tim, that you get the invitation for that. All right, let me try to connect with Rebekah one more time. All right, Claire Gill, you want that invite? Yeah, if you have registered for this one and I've got your email, I'll make sure to add your email address to the training and the bagels uh, listserv. Okay, I'm going to pause this for just a moment. Hang on. Okay, she says she's logging in now. Well, it's still only showing one panelist. I'm not sure what the issue is. Well, I apologize. Sent the link to her several times. I'm not sure what the issue is. I'm going to put us on pause again. Sorry.
It was going to my junk folder. I'm so sorry.
Oh, okay.
And
All right.
I
Well,
had to search the junk folder, but I found us.
okay. All right. Well, better late than never. You look bundled up and
Uh,
trying to stay warm today like the rest of us.
am I going to be able to share my
Yeah,
screen?
you should be. Yeah.
Okay.
Yeah.
And
Um, and everybody is logged in and we're ready to go. So, everybody, this is Rebekah Cotton. She's been to us in person a couple of times. She's our legal aid expert on leases and evictions, and we are very blessed to have her in our community. So, I'm not going to waste any more of her time, and I'm just going to turn things over to her.
thanks so much. Thanks so much for having me, everybody. I'm thrilled to be here today. I did receive a list of questions, which was very helpful in preparing for today's presentation. And I am going to share my screen at times and just kind of talk you through. I just need to find my notes. And I do apologize for the delay because um, it was going to my spam folder, the link, and I couldn't find you. Um, okay, so first, a little bit about me. My name is Rebekah Cotton, and I came back to Kentucky from prosecuting in Virginia in 2021. And since I got there back from Kentucky, I've been at the Legal Aid Society. And my role has mainly been to defend tenants in eviction court. I've also been able to help on other real estate matters for some of our clients, and some collections issues. But 99% of the time, what we're doing is we are defending tenants in eviction court. We have, in the last year or so, been looking at ways to systemically advocate for our clients. And one of the things that we've been doing is reviewing leases, looking at whether or not they're lawful. The timing of this training is just so perfect because I've been sort of just buried in this particular topic. Our office has twice taken landlords to circuit court and asking the circuit court to declare the lease unconscionable and unenforceable because it contains unlawful provisions. So it's a real thing. The leases in Jefferson County do not comply with the law. The majority of them contain provisions that are unlawful. And today we're just going to talk about some of those issues, ways that you can advocate for your clients. As many of you know, there is very little bargaining power for anyone who's a tenant seeking housing. Most of these leases are form leases. The landlords are not going to negotiate. They're not going to amend that lease. You're either going to sign it as is, or they're not going to rent to you. That's the reality that tenants are faced with. Some ways that tenants can fight back is they can join a tenant union. They can form a tenant union for their particular area, and they can advocate for tenants. But for the most part, there just isn't a lot of bargaining power for tenants, and that's unfortunate. However, the errors in the leases and the issues with the leases do become relevant if the tenant gets in trouble and faces eviction. So I am going to go ahead and share my screen. Okay, and you should be seeing my screen. Oh, I need that bar to move. That is just really frustrating. Okay, move this so I can see my tabs. Oh, why are you doing this to me?
I'm blaming everything on the snowstorm.
That's a good call. So I've tabbed everything so I can quickly go to it, but the bar from the share screen was blocking that. So, okay, here we are. Here we are. So home base for discussion about leases in Jefferson County is always going to be the Uralta. And I have that
But we're
bookmark.
not, there we go. I was getting ready to say we're not seeing your screen. Now we've got.
Okay, good, good. And let me know if you aren't seeing what I'm showing you. So Uralta is found in the Kentucky Revised Statutes under 383. I'm not going to read this whole thing to you. Although I would recommend if you're looking at a lease with a client or you're curious about a particular issue, to go to KRS 383 and just look at the titles for each of the different things and see if you can find the answer to your question. I'm going to send this bookmark out to Laura and she'll send that over to you guys so that you have the same one that I'm looking at when you have questions about leases and issues. And I think just in general that the most important thing to understand is what is prohibited in a lease in Kentucky, in not in Kentucky, apologies, in Jefferson County. So the Uniform Residential Landlord Tenant Act is only a piece of landlord tenant law. And up above here, you see just what the basics of forcible detainer law is. Basically, if you don't have the Uniform Residential Landlord Tenant Act, which we do in Jefferson County, but if you don't, then the lease controls. There's really not a lot of additional protections for tenants outside of a jurisdiction where the Uniform Residential Landlord Tenant Act is in place. So it is in place in Jefferson County. And so the lease controls for all other evictions where there's no Uralta. And that's important to understand because people will say, well, they only gave me, 4 days notice, or I'm entitled, to 15 days notice under the lease. It matters what's in the lease. And a lease can expand the rights of a tenant. So sometimes you'll be in a Uralta jurisdiction, which only requires a 7-day notice for non-payment of rent, but they will give 10 days in the lease. The lease controls if they give additional time. If the lease gives less time, then it's in violation of the law. And then that can't be enforced. That provision can't be enforced. And that's where we're going to start with is prohibited provisions. So if you look right here, terms and conditions of a rental agreement, 565. The landlord and tenant can include in a rental agreement any terms and conditions that aren't prohibited under Uralta. So Uralta is all of this, 500 all the way through. If there's something in there that says the landlord's responsible, then you can't include in the conditions and terms that the tenant is responsible. You can't agree to something that's in conflict with Uralta. So if you're looking at a lease for a client and it says, let's just give an example here. Let's look at landlord's maintenance obligations. Your lease can't say in a Uralta jurisdiction that the tenant is responsible to keep the property in a habitable condition. Why? Because under KRS 383-595, the landlord shall make all repairs to keep it habitable. So just understanding and reading through Uralta, you will find a lot of things that you'll see in a lease and you'll go, wait a minute, Uralta says that's the landlord's responsibility, but this lease says it's my client's. That's not right. That's when the red flag should go up. And then you go back and you can see here, terms and conditions. You can agree to anything in addition to or in compliance with Uralta, but you can't include terms and conditions that are prohibited. And you can't change Uralta with a lease. So understanding Uralta is important because you need to know who's responsible for what under Uralta. Then you can go back and look at your lease and see whether or not it aligns with the law. Okay, so they've taken the time. They said in general, you can't include terms and conditions that are prohibited and that change the law. Then they get even more specific because landlords need to be told exactly what they can and can't do. They included this provision in Uralta that says specifically what you can and can't do in a lease. It says, a rental agreement may not provide that the tenant agrees to waive or forego rights or remedies under KRS 383-505-715, which is Uralta. You can't, apologies, client calling in. So if you're having tenants or clients of yours who have a lot of questions or concerns, you can give them the link to Uralta. They can read through the statute. They can look at who's required to do what under the maintenance. Now, how do we enforce this? How do we negotiate this? It just depends on the situation. Most of the time, legal aid doesn't even know that there's a lease issue or a legal issue for a client until they're in eviction court. We're limited in our ability to, in terms of volume, to represent folks on proactive litigation. Um, it's important to know what's in your lease. It's important to understand what the law is, but cooperation is the best way to get through a situation with a lease. Using reason. If you have a lease that says that your tenant's responsible to fix the plumbing, and that's, we can go and look at that right here under landlord's maintenance obligations and under essential services. So the rental agreement, the landlord, they have an obligation to procure reasonable amounts of heat, hot water, running water, electric, gas. Those are essential services. They're required to provide those. Okay. If your lease says that your tenant has to do this, this is what you send to the landlord. You send this statute saying, no, I know the lease says that, but under your RALTA, you can't waive or forego any rights or remedies under the statute. And it says it's their responsibility. So you fight back with the law, you show them what needs to be, what the landlord needs to do. And at that point, if they refuse to fix one of those things that makes the property habitable, that is, quote unquote, an illegal eviction. If a landlord refuses to provide the services that your RALTA requires them to provide, after they've been notified in writing about it and they won't do it, they won't fix it after they've been noticed, then they are committing an illegal eviction by depriving the tenant of those things that they're required under law to provide. So that is when you would contact legal aid and say, my client's being illegally evicted because the landlord isn't fulfilling what they're required to do under your RALTA. Okay. So notice is important. Making sure that things are communicated clearly, making sure that you understand what the lease says, but also what the law says. Because leases, like I said, we're reviewing leases, and we've even taken some leases to the circuit court to challenge them as being unenforceable because they include so many provisions which are outside of the law. The one that I took to court had 17 provisions that violated your RALTA. And this was a property management company that had thousands of units. So that's how we do a review of leases. That's how you can do a review of leases. First, read through your RALTA, see what it says, the landlord's responsibility is, see what it says the tenant's responsibility is. Then you go and look at the lease and make sure that the lease complies with what your RALTA says the responsibilities are. Okay. So that's just a general overview of looking at a lease, understanding the law, knowing where to go. We're going to talk about, I'm going to talk through the questions that were provided to me, and then I'm going to take extra questions. And if I'm able to answer it on the spot, I will. And if I'm not, I will be happy to get back to Laura and provide an answer for any new questions. So the first question on the list that I received was, what are RUBS, capital RUBS, and how are they calculated? So I know what they are, but I thought it would be easier to just read the definition from AI. It is accurate. I know what they are, but I like to have the explanation here that they did. You're going to see this in a lot of leases. Okay. This is kind of a new thing, a way that landlords are managing to collect even more fees from tenants. It's a method used by landlords to allocate shared utility costs among units. It's also something they do in these larger complexes that have shared spaces, like a activities room or a pool, or I don't know, shared spaces. They will allocate the shared spaces utilities to the tenants who enjoy those amenities. So sometimes a tenant will even have both their own LG&E bill and another charge for utilities for shared spaces. I wish we could go back to when I was first renting, which is 100 years ago. That was unheard of. It was just unheard of. You had your own utility bill, you paid for your own lights, your own electricity use, and that was the end of it. This is becoming more and more and more common. And a lot of tenants do not understand, what is this extra utility bill? Well, it's in the lease. And if it's not, you immediately want to contest it. But here's what you're looking for. I pulled up a lease that has it in here. And it's on page 12. This is Heritage Green. Y'all might have somebody in a Heritage Green of property, but they use the RUB system. And you can see under this number 26, the utilities are furnished by the landlord are subject to change. Landlord reserves the right and expects to institute a charge for any and all utilities. Using RUBs, using some calculation methodology. Landlord reserves the right to charge for other operating expenses. This is it's just a junk fees provision. My recommendation, if you're assisting a tenant who is trying to secure a new place to live and you see RUBs or you see some sort of catch-all policy like this, my recommendation to you would be to ask them for the last 3 months from the previous resident, what those amounts were, to kind of nail down what the expectation should be. That way you at least have an idea of what they've been billing before you sign on to this. I have a lot of clients who end up in eviction court because they're not able to handle these additional fees on top of the rent. And they didn't understand their lease when they signed it. They didn't understand that they had agreed to pay these. And so it's frustrating. A lot of the leases will also, they'll say point blank that these are considered rent. Okay, so here's that sentence at the end here. If any utilities furnished by the landlord to the resident are not separately metered for the premises, resident shall pay a pro rata share of the utilities furnished by the landlord when invoiced to the tenant as additional rent. So what they're saying is, if you don't pay this, we get to count it as rent and we get to evict you and allege it as non-payment of rent. And so that can get complicated. It says here at the end, if they don't pay to clean up the tenant's trash, said charge shall be considered additional rent. So in eviction court, there are 3 different ways you can get evicted: non-payment of rent, violation of the lease, or non-renewal of the lease. And you stayed over, okay? Typically, we would argue that non-payment of utilities and non-payment of trash fees and whatever, that those are not rent, okay? The problem is that a lot of these leases allow them to classify it as such, and they can argue that back. Now, sometimes the judge will agree this is not rent and not evict on non-payment of rent. The difference is, if it's treated as rent, you only get 7 days to pay it and make it right. If it's treated as non-payment of utilities or some other lease violation, you get 14 days to pay it. And in a lot of cases, that extra 7 days is the difference between an eviction being filed and not. So make sure to read the lease, make sure to understand what the expectation is. And before signing the lease, make sure that you see a history of what the RUBS charges are before you sign, and that your client understands this is how they're going to treat this, and you don't have control over it. It's going to be a different amount every month. That's another thing that's really frustrating for clients, is their expectations, this was only $12 and now it's $40. And a lot of clients who are receiving services with coalition folks are going to be living on a very close budget. So that's something to look out for. Make sure to read it carefully and ask for more information about what that particular unit has been charged over a period of time so that you can see what it is. So they do it based on different things: square footage, number of occupants in the unit, and etc. Some of them do a flat fee, which people get so angry because the people upstairs who have 5 people living in the unit are paying the same amount as the person downstairs who lives alone. And that's very frustrating for folks. Um, but once you sign that lease, you've agreed to cover that expense. So it's important to know that. Moving on, and please interrupt me, Laura, if there's questions. I'm happy to try and respond, but I'll just keep going on the questions. Can a tenant be held responsible for something their guest does, even if the tenant is trying to get the guest to leave? So I'm going to tell you the rule, and then we're going to talk through some examples of situations. So the rule is that you're responsible for your actions, the actions of your guests, anybody who visits you that you invited onto the property, and typically that's in the language of the lease. And I looked at this on this same lease, and it's actually in the rules and regulations. A lot of folks, when we do an eviction case, they have their lease, but they don't have the rules. So this is something that you should have at signing. You should know what the current rules and regulations are. And the reason why you need to get a copy of it at signing is because these get changed a lot. Now, a lot of leases have in the body of the lease that if you disturb the peace and quiet enjoyment of others, if you or your guest does damage to the property, if you or your guest has altercations or any criminal activity, it almost always, I'm going to just say, it always includes your invitees, your guests, anybody that you permitted onto the property. So let me just show you an example of that here. Disturbances and noise. The residents, family, and guest shall have due regard for the comfort and enjoyment of all other residents. Your apartment is your home, free from interruption, unless you or your guests disturb other residents. Loud noises and disturbing acts in common areas, it's always going to include the behavior of your guests. Drug-free housing. Tenant, any member of the tenant's household or a guest or other person under the tenant's control shall not. They always include this. Now, what can you do if you've invited someone over and all of a sudden they've decided to commit a crime? And you didn't invite them over and you didn't know they were going to commit this crime and you don't want to have anything to do with this. What's most important in this situation is that you act to prohibit their access, that you are very clear that you're asking them to leave, that you are no longer giving them permission to be on the property. You want to do this in writing. You want to do it in text message form. You want to, in front of other people, ask the person to leave. You want to take the position that you are no longer my guest and I'm asking you to leave and I'm not going to be associated with this behavior. And then I want to show you in this case, which I'm going to send a copy of this case to you guys, but I'm just going to tell you about it if you're really interested in this issue. The case is Housing Authority of Covington versus Turner. Now, in eviction court on lease violation cases, you would be surprised. No, you wouldn't. You wouldn't be surprised. You guys have seen it all. You would not be surprised that a large number of lease violation cases are the landlord trying to evict the tenant because of something that one of their guests did. This is not uncommon. And what we do is we argue right to cure, and we argue this Housing Authority of Covington versus Turner. The problem that we run into is when the tenant will not prohibit the guests from coming to the property and they continue to invite them. We can't win a case if you persist in inviting someone who's a problem. If you've been warned about it and you continue to invite them and they continue to to cause problems at the property, that's going to affect your ability to remain there. So something happens and you withdraw your consent for them to be there. If they do something violent or something, whatever, you may even want to go and get an EPO if you can, if it's appropriate. You may want to contact law enforcement and explain to law enforcement that you want a report made, that you've asked them to leave, so that you have a record or a document stating that you no longer are inviting this person. Now, in the Housing Authority of Covington versus Turner case, it was like a mom or an aunt, I can't remember, and then they had a teenage child, I think he was of age, who was involved with some substance abuse issues and had substances on the property. And he was arrested, and there was a charge for possession at the home. Then she got the notice letter from the landlord stating, we're moving to evict you because your guest has violated the lease. They have been involved with illegal substances. There's a charge. The woman, and that's this drug-related criminal activity. You can see that here. That's a very common lease provision, okay? Use, possession, or possession with intent. Any kind of involvement with drugs. In the case, I think it was the aunt, I don't know, I can't remember, mom or aunt, I apologize. She forbade him from returning to the property. And he went to live somewhere else as soon as she got this notice letter. Well, the landlord came in and said, this is not curable. This is horrible. This is dangerous. We're a no tolerance facility, blah, blah, blah. And the judge found in this case that she had availed herself of her right to cure, that she had forbidden him access to the property, and that she no longer allowed him to stay there, and that they couldn't evict her because she had cured. And even a criminal charge is something that you have the right to cure. If you do not allow access, then you have, in effect, you have withdrawn your consent for that person to be on the premises, and that's going to protect you from being evicted if you act quickly to make sure that whatever the lease violation is, that it's not going to reoccur. Okay. And now I just want to take you to KRS 383 again, which is where we live. And this is, 300. You guys should make yourself aware of these two provisions if you're dealing with anyone who has a history of domestic violence of any kind. If you have anyone who has a history of police involvement, or an abuser, these provisions were specifically put in place to protect the person who's being abused from losing their home. So these are important provisions. We use these in eviction court. If someone has a domestic violence order against someone else, even if they are on the lease, and that domestic violence order is in place, you can break the lease and move. There's different things that you can do because of that particular instance, and it's all here. You guys are grown-ups, so I'm going to send you the link to the 383, and then you guys can look these up and read through this yourself. All the protections having to do with domestic violence or interpersonal protective orders require an actual filing, not a complaint, not I called the police. There has to be an actual order from the court for protection, and then these provisions provide.
And
So definitely, don't wait around. Don't wait to act. Encourage individuals to protect themselves. We have a whole unit whose key thing that they do at Legal Aid is assist individuals who are being abused or in a situation where they need a protective order. So that's something to absolutely call legal aid about, and request representation.
Yeah, and we're going to do a separate training in a few weeks about the VAWA protections
Good.
because if there's HUD money involved, then there's a lot of documentation that has to go along with all of this. Forms that have to be kept in the files, things that clients have to sign up front, and a lot of rights, both on the client side and on the agency serving the client. So it's important, excuse me, that if you haven't made yourself aware of this, go ahead and look at this information that Rebekah's given you, and then be on the lookout for a training coming up in the next few weeks.
That's awesome. Thank you, Laura. Um, and again, legal aid, we have, I think our two biggest priorities are emergency protection for individuals that are facing violence and housing. So if you have an incident occurring with those two things, those people should be legal aid clients. Um, and it's interesting since we're talking about leases today, a lot of the HUD leases will reference VAWA, but VAWA is vast. um, and hardly anyone ever even knows about this 300 provision, and it's very specific what your rights are as a tenant. So if you have a client who has a lease that's referencing VAWA, print this out. Print this out. This is the law in Jefferson County, what their rights are. And then the other piece is we see a lot of lease violations where individuals, um, they contact the police repeatedly, and that's annoying to the landlord and annoying to the others at the unit. And they try to evict them for having that excessive police contact. Um, it says point blank that there can't be prohibited, I'll just read it, prohibited inclusion in a rental or lease agreement of authority to terminate on the basis of tenant's requests for assistance in emergencies. So if it can't be in the lease, it can't be enforced in eviction court. See what I'm saying? Like, how are you going to get someone on a lease violation for calling the cops too much when you can't have any prohibition included in your lease agreement for contacting emergency services? You can't. And we're going to show this to the judge. You get a notice letter from a landlord that says your client's calling the police too much. You need to print this out and hand that to the landlord. You cannot be evicted for availing yourself of emergency services. Um, so that's an important rule. It's something to be aware of. Um, and this one is really fun because if the landlord tries to enforce a rental agreement for that, the tenant can get damages and attorney's fees. So, 2 months rent for saying I can't contact the cops or trying to evict me for that. Um, so that one's fun. They can't do it. They're not allowed. All right. So now moving on to the next question. And I hope that, can you be held responsible for something your guest does? So just to be clear, we're not talking about can you be held responsible criminally. I'm not a criminal law attorney. This is not a criminal law discussion. I don't know what the involvement of your person is with whatever is alleged. Um, that would be on a case by case basis that we would review it. But in terms of the lease, if they were your guest, you need to make it clear at what point they no longer became your guest, and you need to protect yourself by making sure that that's well documented. Um, and then at that point, we would defend you. And I will tell you one more story just because it's a good one. I represented a woman whose brother came over to visit, and he was playing video games in the house. And this guy that knew him showed up at the front door and shot her brother in front of her. And then they tried to evict her for criminal activity. That man was never her guest. That man committed an act that was unthinkable. It's not anything that she could have ever prevented. And they were evicting her for what had happened. That she is not responsible for that in terms of the lease and in terms of a lease violation. If you are the victim of a crime, you cannot be evicted for that. It's just wrong. And it's something that's absolutely a case that you would want to contact legal aid about to ensure, that you have a good defense and that a trial is requested, because it's just unthinkable. It's unthinkable that someone would be evicted for being the victim. Okay. What if a landlord never returns a deposit? Okay, so I will start with, I think we get calls about deposits more than anything else. We all know that they're going to keep it if there's any way they can. That is the expectation. It should be the expectation. Most folks who are calling us about a security deposit left the location that they were in owing rent. And so most leases include a provision that says that the security deposit will be, processed the way that KRS 383-580 says, but then it will be applied to any balance due and owing. Whether or not it says that or not, you don't want to sue to get your security deposit back if you owe rent and it's more than the security deposit. You need to let that go. If you sue them to get your security deposit back and you owe 3 months rent, you're going to end up paying when there's a good chance they probably never would have filed suit to collect on the owed rent. So you just got to use your head when you're advising clients on this. Yes, it's wrong. Yes, it's a problem. Yes, they need to return security deposits. And they need to follow the statute. But at the end of the day, if you owe more than that security deposit, it's not in your interest to pursue it. So that's the first thing you need to look at with a client who's upset about a security deposit. Then you can go through the statute. A lot of landlords do things wrong. They don't keep the security deposit in a separate account. Some of them do, some of them don't. That's required by the statute. They have a very specific process laid out where there has to be a walkthrough on the front end and a walkthrough on the back end. If they don't do that and it wasn't your client that refused to do it, then they can't keep the security deposit. Those are required steps. They have to provide a list of all the things that they're taking the money out for. A lot of times leases will have a fee list up front, and it's crazy. Okay, it's $100 if there's trash. It's it's just those lists are just ridiculous. But your client signed the lease. This is what they said that they were agreeing to. It's really hard to fight back against something that specifically, it says. Something we do see with security deposits where it may make sense for you to fight back is when the tenant reported an issue and the landlord didn't come in writing. Everything has to be in writing, guys. Everything has to be in writing. Tell your tenants, don't call about a maintenance issue only. You can call, but email them, text them. I hate text messages. I hate them in court. I don't think anybody should be texting with their landlord. I take that back. Don't text with your landlord. Email them. If you call them, email and said, thank you for talking to me today, and this is what we discussed. When we get into text messages, the judges just get annoyed because it's back and forth, and usually they're, cussing each other, and it's just not productive. We have some specific letters that we give to folks about this, and I will send those to Laura afterwards. They're just sort of form letters. but they have to do the inspection before and after. They can only retain what isn't normal wear and tear. Um, I will tell you, I have yet to talk to somebody about a security deposit who didn't owe more than what they wanted back. Um, it's just it's helping the tenant to understand that that you know you owe more than what this is. You need to let this go, and hopefully they won't pursue you for the back due rent. The one thing I will tell you is this: if your tenant is sued in collections or receives a collections notice for rent, past due rent, you want to make sure that the security deposit that wasn't itemized out, whatever remaining amount was applied to that balance. A lot of times they don't apply it to the past due rent balance in a collection case. So you want to absolutely check and make sure, hey, they never sent a listing of things. They never returned the amount that was due. Hey, this should be applied to this balance. They don't owe that much. So that's something to look out for tenants if they get sued in collections. So this is one to have on hand. It's all right here. And you don't need an attorney to sue in small claims court to get your security deposit back. You just need to have your information. You need to go through the statute and show the judge that you're entitled to it to be returned. Hopefully, by the time you get done paying the filing fee, getting the person served and all this and that, you're probably going to have spent the amount. So I wish that was better news. I hope that's helpful. But yes, you do have the right to sue in small claims court, and I will send out the little packet that we have on small claims and how to do that. All right. Can a landlord make changes to the lease in the middle of the lease period, or do they have to wait until it's time to renew? Do lease changes require a signature from the tenant, or can the landlord just send out the notice? This is a great question, and it's very important. I'm sorry, I need a drink. So the lease that you signed is the agreement between the parties. After that lease expires, it automatically by law becomes month to month if you continue paying rent and they continue accepting it. And nobody has sent a notice letter saying we're not renewing. It becomes a month to month lease on the same terms for the same amount of money. We have seen all the time these crazy landlords who say rent, they send out a notice to everybody, rent's going up by 3%. And it's going to happen in a month. And then they just start charging that additional amount. Well, then they come to eviction court and they allege the non-payment on the amount that is in addition to, and they're like, oh, well, we gave them notice. Well, that doesn't matter. The tenant didn't agree to that in writing. They're not responsible for that amount of rent. And you had the opportunity to not renew the lease if you didn't want to continue with the original terms. No. So the answer is no. You can't change it and enforce it without consent by the tenant. And middle of the lease term, landlord's out of luck. They cannot change the amount of rent before the first year is up. Now, if you're month to month and they send a notice and they say, you're month to month, now that you're month to month, it's going to be an additional blah, blah, blah. If you don't sign anything saying that, if you don't consent to that, then they need to go ahead and non-renew the lease. You haven't agreed to pay additional rent. Sometimes people get hung up because they don't read the lease beforehand. A lot of leases will include in the rent section that once the lease becomes month to month, there's an additional fee if you don't enter into a new lease. So the short answer is no, they can't change it during the middle of the lease period. They absolutely can't do that. You didn't agree to that. You have 1 year at this amount of rent with these conditions, and that's what you agreed to. After the that period passes, they have to give 30 days notice. And if you don't assent to the new changes, then they can't enforce a lease that didn't exist based on a notice. You have to agree, or they need to ask you to leave and not renew your lease. So we see this a lot. Now, one of the things that people, and I'm going to show you this in Uralta, under 610. Rules and regulations. So remember earlier I was showing you on the Heritage Green Lease how they had that whole section of rules and regulations. A lot of times there'll be additional fees, there'll be additional things in the rules and regulations. It's important to know your rights under a rule and regulation. So a landlord from time to time may adopt a rule or regulation concerning the tenant's use and occupancy. So say the landlord wants to say, nobody can have a grill, okay? It's a new rule because some fool did something with a grill and now nobody can have a grill, okay? If that's for safety, convenience, welfare of the tenants, it's to protect the landlord's property. That is okay. The purpose needs to be for one of those reasons, but they have to enforce it against everyone. They can't discriminatorily say you can't have a grill, but you can. So it needs to be enforced equally. And it needs to be, like it says here, it applies to all the tenants in a fair manner. There needs to be notice of the new rule. And it needs to be, I think it's the period. I think it's 30 days if you're paying monthly. But in addition to that, there needs to be notice to give people opportunity to comply with the rule. And then the second thing is, if it so substantially modifies the agreement, the tenant can say, this so substantially modifies my lease that I can't stay here. Okay. It wasn't bargained for. So say that the no grill rule, say that the guy who lives there has one of those businesses where he's always grilling and feeding people, and that's where he stores his grill, and he can no longer live there. You could argue that that's a substantial modification, and that's not a valid rule. And it's not enforceable against the tenant unless they can prove all these things. Okay. We have argued in the past that it was a substantial modification of what was agreed to, and that we should be able to break the lease, or the tenant should be able to break the lease. An example of that was when this was all over the news. There was this one place that did substantial renovations, and they were going in and like replacing whole kitchens while people were living there. It was terrible. We argued that was not agreed to. Couldn't do that. So that's an example of changes. If you didn't agree to it, one thing that does kind of get tricky is you have a tenant who doesn't know their rights, doesn't know the rules, and they've been paying $700 a month to live here. And the landlord says, I'm going to bump the rent $50 a month. Nobody signs a new lease. The person pays the $750 for like 6 months. Okay. And then they get behind and the landlord seeks to evict them. So you can make an argument that they never agreed to pay $750 a month, but you have the problem of their assent. The fact that they willingly paid it for 6 months, which indicates agreement. So that can be a problem. I would encourage folks to continue paying the same amount of rent until they decide that they no longer want to lease to you, if you're not willing to assent to the new amount. If you agree to it, you should get it you should get it in writing so that you can have a year-long lease and protect your interests too. Um, okay. We're on question number 5. How's everybody doing? If the landlord offers to let the tenant do work in exchange for lower rent, is this a separate agreement or should it go in the lease? Okay, so this gets sticky because employment bumps you out of your RALTA. And this is 383-535, exclusions from application. So if you're excluded from your rights under your RALTA, specifically under this statute, then all you have is the agreement between you and the landlord. It's just like non-URALTA jurisdictions. The lease controls, the agreement controls. It's a contractual relationship, and you don't get all these additional tenant protections if you are operating under this. So it states point blank here under number 5, occupancy by an employee of a landlord whose right to occupy is conditional upon employment in and about the premises. An employee of the landlord who's allowed to live there or gets their home as compensation for their employment is excluded from your RALTA. So the only thing the judge is going to look at is the lease agreement between the parties and the whatever the employment agreement is. And if they're not living up to their employment, they aren't even going to be entitled to like statutory notices and stuff. It's going to be based on whatever the agreement says.
Rebekah, what we see in a lot of these leases is that the landlord will say, I'll knock $100 off of your rent every month if you'll keep the trash picked up. It's not even a formal employer-employee relationship. You know, they're not taking taxes out. Um, it's just, I'll give you a break if you'll help me out.
And sometimes that break is, really great for the tenant. And I can see that. If it's just like what you're describing, I think that you should advise the tenant to keep it separate completely, request to be paid and paid, it maybe it's sort of like fictional, but get a receipt for payment and pay your rent with that and keep it as separate as possible from the lease scenario. And make sure to get a receipt for that kind of activity. I don't want people to not have the option to make a little extra money to help pay their rent. But I think it's also important to make it clear that you are not my employer. And they're really, there's a lot of under the table stuff that goes on out there. I can't really condone it. If you're doing that every single week, you're crossing into the gray area with whether or not you're an employee. And if it's more than half the rent, I would argue you're absolutely an employee. So it could be argued both ways, and this is sort of on a case-by-case basis, but to protect the tenant, you want to keep that stuff as separate as possible. And I think as soon as you become an employee, I don't know that would be a conditional upon employment. So the landlord isn't saying to them, if you don't do this, you can't live here. So their living situation isn't conditioned upon them completing that task.
Right.
And that is an important distinction. But the longer that this goes on and the more that it is, the expectation is that this will be done as you're expected to do this in order to remain here, the more you give up your rights under your RALTA and you have a weaker case. And so it's important to clarify the relationships and just understand going into it, and you can put in your employee agreement and in your lease that you're required to give me the same notices required under your RALTA. You can agree to that. Um, it's not going to be applied because of your alta. It's going to be applied because of what you agreed to with that landlord. Does that make sense? I hope that makes sense.
It makes
Um,
sense to me. If it doesn't make sense, raise your hand.
the terms of the agreement control the closer you get to being an employee, and less of the Uralta tenancy protections. And so you want to make sure that if you're going to be working as part of your rent, that you have good terms in your lease agreement and in your employment agreement, to protect you. Because it may be that the judge will say, I think that this is employment for tenancy, and exclude those additional protections. Um, is a lease enforceable if the landlord never signs it? Okay, so the basic answer is no, but there's a lot of arguments that the court should enforce the agreement by pattern and practice. Um, so you want to say there's no lease because the landlord never signed, but the landlord and the tenant's paid the exact amount under the lease for this number of years, and the landlord has done this, this, and this. So it just, there is arguments around that with pattern and practice. Just like I was saying about the assent to a change in rent, it would be difficult if the tenant paid the 750 and not the 700 written on the lease for a year, and then tried to say I didn't agree to that. Sort of looks like you did agree to that. So there are arguments against it, but the easy answer is no, it's not a lease agreement, enforceable lease agreement, until there's evidence of assent that they signed, that they agreed to it. The tenant moved and turned in the key but left belongings in the unit. The tenant made an appointment to come get them but didn't show. Can the landlord dispose of the belongings? Okay, so this again is sort of a circumstantial situation. I would not want to take that to court. Let's put it that way. They had an opportunity to come and get their things. They didn't take advantage of it. But I think that there is an obligation of good faith in performance. So if the tenant had, clearly communicated, hey, my mom passed away and I wasn't able to get over there and I couldn't get my things, and they knew. I think that there's an argument of good faith that's up here, you know, to perform with some humanity. But that would be something I would not want to litigate. After you've handed over the keys to your apartment and you've moved, you've given up possession to the property. This one is really, this last question that we got, Laura, is really an interesting question, and there's a lot going on in the state about this issue. So I'll read the question, and then I'm going to show you in Uralta the things that I think are relevant. This is more of a scenario. I often hear people have interactions with police during domestic disturbances and want to get a guest out of the house after they spent the night. The police often say they cannot remove someone due to a toothbrush law. They advise the landlord has to file a formal eviction to get the guest out that refuses to leave. It's then been shared that the landlord will not just evict one individual, but all the parties involved. I've heard this from multiple divisions of LMPD. Can someone help me understand? So this is a question for the Louisville Metro Police Department. It is not a question for me. Why are you doing this? What is the basis for these decisions that you're doing? But it has become a big issue. And now there is a new law on the books about removal of person unlawfully occupying real property. Um, so this was recently passed by the legislature, and it's my understanding that law enforcement has been very wary to enforce it because they believe that it's going to turn into illegal evictions of folks who have a right to occupy. But this allows you to file a form to have someone removed, and you have to state all of these things on the record, that you're the owner or the authorized agent, that you're the owner or the authorized agent, that you obtained title, the person is unlawfully entered. So you have to swear to all this stuff, and then you can take it to the police and they can either serve it or not. My understanding is that they're not doing this because they're concerned that the folks that people are trying to get out actually do have some sort of tendency. Legal aid would advocate for the folks who are being asked to leave on most occasions, unless they are a DV abuser. Um, in a domestic disturbance, if you're trying to help the person get the person out, um, that's you need to avail yourself of the police. You need to say that this person has no tendency here, that they're not on the lease, that they have not ever been an authorized guest. There's good key language to say that they're trespassing, that you are not inviting them, they are not your guest. Um, and just stay away from buzzwords like, and you want to stay away from too, like, how long has this person been staying here? It's really hard for me to believe that the police would not remove someone who'd only been there one night. But I don't know. You guys are in the thick of it, and somebody has seen this because they're writing it. They're writing this question. Um, so it's for the police on the ground to make the determination if this person's a trespasser, if this person is not allowed to be on the premises. It's good to have a copy of your lease that shows who's allowed to be there and who's not, and show it to the police and say this person has no right to be here. um and that's a tough situation, and one that you need to just go into it armed with your lease. It might even be, I mean, you can't control. Property managers are always trying to evict people because they're availing themselves. I'm going back to this. They're availing themselves of emergency services. And you can't control the property manager's ridiculous response to these situations, but you do have a defense to that. If they are evicting you because you contacted the police to get help, that is absolutely something that should be raised, and legal aid would represent in that situation. So it's a case by case situation for sure. If someone's been living there and contributing to rent for a period of time, that's going to get really sticky. So those were the questions that I had, and I've done my best to.
You got through a lot of information in a short amount of time.
um, Leases, I mean, you guys don't be surprised. I like I said, the one lease that I took to circuit court, I literally found 17 provisions in the lease that were unlawful. They had said that the person wasn't entitled to notice. They had said that the person wasn't entitled to the jury trial or a trial at all. They had said that the person agreed to pay attorney's fees and court costs, which is in the prohibited provisions list. And we know for a fact that folks are paying attorney's fees and court costs all the time. We just don't have a way to prevent that from happening, except for to educate folks on what their rights are.
It's crazy that anybody can become a landlord with no prior training or requirements for knowledge of the law or understanding a lease.
Every single day in eviction court, I'm amazed at the errors that I see. Um, this one lady, she got a notice letter that she owed like $3,600, and her portion of her rent was only like $220 a month, and she was only two months behind. Um, yeah, there's a lot of error, and the best way to try and resolve these things is to present the lease and to present the documents and try to get on the same page with them. There's a lot of ignorance in the property management world. I hope this has been helpful. I know I talked fast, but I wanted to try and get through these. And I am going to send Laura, I'm going to send a link to the Uralta page that I've been scrolling through. And then I will just send a list of the particular statutes that we looked at today.
That'd be great.
Um, and then, absolutely, if you have a client with an issue where they can't stay in their home because of something, the landlord won't fix it. Like they're basically losing their home because there's no heat, or they're losing their home because the landlord won't put a lock on the door. These are things that legal aid can advocate for folks. And then, of course, if your tenant is facing eviction, we'll do everything we can to try and buy them more time or address the issues.
And I hope that maybe later on this year, maybe when the weather's a little warmer, we can bring you back for that eviction training. You've done that twice for us, and it is both years. It's been the most popular one we've done, and people still ask about when are we going to do that one again? So
Thank you. I'm so happy to present. Happy.
good, good. We'll get you on the books for maybe sometime this summer and do that one again. So, does anybody have any last questions or comments before we close this out? If not, you'll have Rebecca's contact information. I'll send that out to everybody this afternoon and with your links and just get in there and dig through that Uralta. And then if a question pops up, something doesn't make sense or you don't understand some terminology, then you've got some resources to reach out to, help me understand this word or this phrase to better protect my clients. And Rebekah, you are such a good advocate for our clients and for our case managers. Thank you so much for giving us some time today.
Thank you
And
guys. Thank you for
this
being boots on the ground.
this this will be on the coalition's website probably sometime next week. If you want to go back and watch the recording again, you can do that. Or if there was someone that wanted to participate today and they couldn't, they'll be able to access it that way.
Okay.
Thank you so much. Everybody
Thank
stay
you.
warm.